guys next week. But I found this meme because like the whole movie Willy Wonka is about a contract dispute with exculpatory clauses. So, all right. So let's just before we get into the trial itself, just a quick recap. So no class next week because I'm going to be on a boat, and for the balance of the semester, we're going to have teams 5 and 6 on call for the next class. And then the 5th, we're going to have like a class debrief on teaching methods. And also I'm going to be meeting with students one-on-one, just like I did at the start of the semester. I'm going to be doing that the 5th, the following Tuesday, and the following Thursday, which is the 12th. And that's it. We're going to have an in-class final exam for extra credit. There's not really any studying you need to do for it at all. It's going to be a comprehensive list of questions that are from the actual bar exam that cover the subjects that we covered in class. Okay, so it's like a challenge to see how did you guys learn? What did you learn on the class? But I don't have really a study guide or anything. Just I'm ready to think, and so but we will cover that on the 12th. So and then finally, before we get into the trial itself, this is the final grading matrix. We're going to have class participation is pegged at 130. Now, a lot of you have more participation points. I did update those last night to get through class on Tuesday. So then we've got 10 quizzes, four papers. Some of you guys need to submit papers. It's very difficult, if not impossible. It is impossible to pass this class and not submit a paper, just for the record. Nobody has ever done it. Nobody's going to break that barrier in this class. So no matter how much you participate today and Thursday or and that following week, it's not going to happen. So all right. So let's get started here. Today we're in Indiana on our tour of courts. We've been in South Carolina, we've been in Rhode Island, we've been in Circleville, and now we're in Indiana. Where was the other location? We were in Cincinnati for the 6th Circuit Court of Appeals. Okay, so yeah, so our grand tour of courts today is Elkhart County, Indiana. Today's docket: Ronald King versus Admiral Nelson. I'm the Honorable Matt Fields presiding, of course. So here's the trial structure. We're going to have opening statements from each side, a statement of the case from the plaintiff, and rebuttal by the defendant. We're going to have cross-examination by the parties where they can ask each other questions. I'll do some final judge questions. We'll have closing statements, and we'll go into the jury instructions. So, all right. So that all being said, let's start with the opening statements. Opening statements for the plaintiff.
Your Honor, we are the law firm of Shepard, Rosales, Smith, and Tidwell. The case set before the court is about the negligence and recklessness of the various organizers and their sponsor, Admiral Nelson. My client, Ronald King, is compromised circumstances was made to sign a binding exculpatory contract out of duress and furtherance of negligence of the defendants. Ronald was a young, impressionable competitor who had been through defective medical care, underage exposure to alcohol, and failure on the part of the defendants to ensure his ability to raise safely. We will prove that in his intoxication, informed consent not being given, and the negligent acts of the defendants presented a foreseeable risk of harm to show the exculpatory contract is invalid.
Okay. All right. Opening statement for the defense.
Your Honor, we are the law firm of Ryan, Ralph, Bottoms, and Gomsel, and we are representing our client, Admiral Nelson and Elkhart Grand Prix. This is a case of a man trying to get out of a contract that he signed after he made a mistake, a contract he had been accustomed to signing for many years now. And now for the first time that the contract inconvenienced him, he is trying to get around the consequences. Ronald King is a very experienced racer, competing in races since he was 15 years old. He has been signing exculpatory contracts the entire time he has raced and knows the protocols of these dealings. We will show that Ronald King knew of the contract and the risks that he was undertaking and ratified this contract when signing off a second time and entering the race.
All right. All right, so this case is predominantly, has everybody had a chance to read all the facts of the case? None of the facts are disputed in this case. We don't have any expert witnesses. Though we may have something, I may bring up something. So we're gonna have, so let's talk about the rules of the road. So the rules of the road for exculpatory clauses are this. In order for exculpatory clauses to be enforceable, they have to have all three of these things. They have to be reasonable, not violate public policy, and not protect parties for liabilities for intentional conduct, right? In addition, we have two other rules that come into play, or sets of rules that come into play, and they're generally the same. They're for being a minor, where the general rule is that it's voidable, but contracts can be ratified when you each reach the age of majority, and intoxication, which you can also disaffirm if you lack the mental capacity to comprehend what you're actually signing, the legal consequences. That also can be ratified at a later time. Those are the rules of the case. Those are the rules that we're following. So with that, I'd like to turn it over to the plaintiff team for their statement of the case.
Okay, so first we want to go over what an exculpatory contract means. So it's one party of liability in which damages occur during the execution of a contract. It aims to prevent legal problems from arising from wrongdoing or negligence. This is generally enforced if if conflict does not exist within the public policy. So then we want to say that Ronald first competed in the Grand Prix when he was a minor. So he signed a contract, and contracts that are signed by minors are voidable, which indicates that there is no way to be ratified after you turn 18.
Okay. So the argument you're making is that's the so he signed it as a minor. Okay. All right. Okay. And what about, didn't he also sign as a over age 18 person?
Later.
Later on.
Yes. So then we also want to say that Ronald was intoxicated when he signed the contract, and having been intoxicated, he signed the paper, and this demonstrates his reduced capacity to understand what he was writing or signing at the time.
Okay. All right. Any arguments about the exculpatory clause itself? Whether it's too broad, protects people from potential conduct, etc.
No.
Okay. All right. So let's turn it on to the opening statement for the defense. Let's go ahead.
So in the first contract that was signed, it was signed when he was a minor, and he was obviously 17 years old, so his parents were the ones that signed with him. But in order for it to be voided, it has to be disaffirmed. So there has to be an action proving that he is no longer abiding by the rules of the contract. Well, when he went to the doctor and they found nothing wrong with him other than the pain, which was his fault, he should have asked for an x-ray in the first place. He did not. So then he was prescribed medication. And then, so he did not plan to sue after that. He did not sue after that. He went ahead and signed an additional contract for the next race. So that time between the first contract being signed and the second contract being signed, he turned 18 and he did not sue. He did not show any disaffirmance action for that first contract, which would have been voidable if he would have shown any action of disaffirmance.
Okay. All right. What about the contract that he signed when he was 18?
The contract he signed when he was 18 was valid because it did nothing to violate public policy. It was obviously reasonable because of the type of event he is in. It is widely known that Grand Prix racing is dangerous. there are a lot of injuries that can occur with bumping into guardrails or bumping into other vehicles. So it's no different than at a skiing resort when you have to sign the form. It's no different than a skydiving resort when you have to prove that there should be no liability if you decide not to put on the backpack. So,
All right. Okay. All right, so we have the groundwork here. So let's go to so we have a statement, that's their statement of rebuttal. Let's do, did you have either party have questions for the other side? Yes.
So I think it's important to realize that the Indiana state law says that exclusionary provisions are not permitted under the state law to protect a party from liability from gross negligence, which the racers organized like this. They had this organized competition, and he signed this form, and he was under the influence, so that should void the contract.
Okay, so and a further thing is that although this case is about the exculpatory contract, there's a further element because once we get past the exculpatory contract, you still have to establish as a plaintiff team that there was a duty, it's a standard tort action. There was a duty that the race organizers had towards Ronald, that they breached that duty, and that breach caused harm. Okay, so can you make sure that you argue through the elements of that thing before we go any further? So what was the duty, how was it breached, and how did the breach of duty cause harm?
Okay, so the duty for the race and the Admiral Nelson was to provide a safe race, and with the photographer being in the way, that breached that duty and then caused him to wreck, and then consequently he had signed this contract, which in that case prohibits them from any liability. And the argument here is that he should not have signed the contract to begin with because he was under the influence.
Okay, so we got two different sets of contracts that we're talking about, right? We have contracts that were signed as a minor, and then we have a contract that was signed while not a minor, but while intoxicated. Right, that's the lay of the land. Okay, all right. Okay, so does the defense have any questions that they would like to ask or bring up?
Yeah. So how did your client become intoxicated and then sign the contract?
So he had taken medication for his pain, and then one of his friends gave him a drink that he didn't know had alcohol.
How did he sign the contract? What did he sign it as?
He signed it as an autograph.
As an autograph. Does anybody here? Can anybody here do cursive? You can do cursive. Come on here for a second. All right. So his name. What's his name?
His name is Ronald King.
All right. So right in cursive up on that word, just like kind of like a sloppy Ronald King. That's right. Ronald King. And how does he sign the actual contract?
The real King.
So sign the real King underneath that. No, not that. But just put real King.
Oh.
All right. So those are the two signatures. Here's the real signature. Here's the fraudulent signature. Can you tell the difference between those signatures? Yes, go ahead. Did you have some question about this?
Well, reading the facts here, it does say that he signed it the real King with the word "the" in front.
Yeah.
Okay, so you say the real King. Okay, so there's evidence that even though you've got relatively similar signatures, there is a reason why they might not have understood the signature to be a valid signature. So, okay, All right, so go to one. Thank you so much for your participation. And sloppy handwriting. So, all right, okay, so let's go through the facts of this case. So, and let me ask a few questions. So I'll start with the plaintiff side. So you're wanting to show that Ronald was not aware of what he was signing, unfamiliar with it, and is disaffirming it, right? Even though he didn't expressly disaffirm it until he kind of filed suit. Shouldn't he be aware of how exculpatory contracts work? Isn't that just a part of racing and racing culture that you understand that if you're going to do these activities that you have to sign these types of agreements? You would say so? Okay.
I would say so, but I think the mixture of the alcohol with these drugs can impair anybody.
Okay. So
regardless.
so in effect, your argument, it sounds like you're saying is that that even though in a normal, if he was in a sober state of mind, not hungover, not whatever else, he might have understood that, but because of his condition at the time of signing the contract and even in the race itself, it might have affected his ability to fully understand the implications of what he was doing. Is that the argument that you're making?
Yeah.
Okay. All right. Turning to the defense, right? Like, why should the defense be able to get out of, or why should you be not held responsible for placing a photographer on the course right around a curve that may or may not result in people reacting poorly to that and potentially injuring themselves?
So this was the second event that we've had that Ronald King has been a part of. So this is the second consecutive year that he's been in this exact event. So we had that same photographer in the past event at that same spot. And in the past event, he was not hungover and he did not even get close to colliding with that person. Neither did any of the other participants because he was in a spot that was normal for a photographer to be in. You know that when you go into these highly coveted races that there are going to be people documenting this action.
So he should have been aware of it ahead of time that there would be people that would be doing this type of activity,
Yes.
etc. And he's not an inexperienced racer. Okay, all right, that's good. Okay, in terms of, okay, I don't know if I have any other questions. I just want to make sure that we've got through all the elements that we got through. So both sides have argued about the exculpatory clause, that both of you kind of have conceded that it was relatively reasonable. Okay. So then
one more question.
Yeah, go ahead.
Yeah. So whose fault exactly was it that he was in the state he was in while he was racing? Was it his fault that he had attained that fracture? Was it his fault that he was surrounded by alcohol?
So Admiral
Was it his fault?
purposely constructed a venue where children could obtain alcohol, and although he was inadequately in control, he was not under the assumption that he had drank, and then he had taken medication because he wasn't under the assumption of that. So, in my eyes, I don't believe it's his fault.
So who gave him the drink? Is what I'm asking.
His friends.
His friends. Okay. So his friends gave him the drink that he mixed with the medication that he got from being an incompetent racer.
But also, the bartender that was serving him drinks also saw the state that he was in and made comments about it. And he works for this racing company, and he knew that that was the state that he was in, and it did say.
So what did the employee tell the person that made him sign the contract?
he asked him if he was okay, and the bartender shrugged his shoulder off and allowed Ronald to drink.
He said that he had drank Coke. That's what he had been served. Because that's what Ronald ordered from the bar is a Coke, and that's what he was given. It was the friend that switched the drink, unbeknownst to the worker.
But it also says the bartender recognized that he was intoxicated.
Well, I personally think if the bartender sees something like that, he should take the drink away because he's part of the company. And like he's the one being paid to do the serving, right?
But see, he did not
So-
give an extra drink. He served it to one person, and then that person took his own drink and switched it. He did not serve any drinks to him.
Regardless of that, was the friend a minor as well?
See, that is not given in this information.
Let's assume that they're both minors.
Why would we assume they're minors? without
Because
getting
they're both-
information? We don't assume things.
Let's assume.
Leave those facts.
Facts.
We can
So-
assume that he is probably a minor because
They are
the
together.
competition is, they're all around.
So, okay, so one big question that both of you guys have not answered yet, and I want to make sure that we get the answer out. On the day of the race, Ronald signed a form that had a checklist that included executed exculpatory agreement in the checklist. Why is that, or is that not a ratification of the contract? Because he signed that when he was over the age of 18. So why is not a ratification? Why don't we start with the
Well, so in contracts, if you start the process of the deal, then that means that it is ratified. So you have the first contract signed. You then sign off a checklist again that it was signed in a completely sober state. It was the day after the drunk incident, and then you go ahead and race under that contract. So that means it is ratified,
Okay, what would the effective ratification be for your side?
that the exculpatory agreement stands.
All right, how is that signing of this checklist not a ratification?
Okay, well, let's say that Ronald the next day was very hungover and seeing the contract, he did not read the full list. Like it said, he did not read the list before he signed it. So he signed it anyways.
Okay,
Because of the state he was in from last night. I don't think anybody that has a headache and has had a rough night would go through the contract.
okay. And is your further argument that they're on notice of his condition
Yeah.
because they saw it? Okay, all right, those are good things. All right, why don't we give closing statements to each side, and then we're gonna break you guys up into juries and decide this case. So we'll start with the plaintiff. Go ahead.
Your Honor, the current case exemplifies all that can go wrong when ignorance and a lack of accountability and are practiced in competitive circumstances. The evidence shows that Ronald King was in no position to grant informed consent when he signed the exculpatory contract. Is intoxication and impairment from the defense acts and omissions were so severe that he could not have understood even superficially and the obligation or rights he was giving up. Admiral Nelson and the race organizers broke their duty of care by distributing alcohol recklessly, ignoring obvious symptoms of Ronald's impairment and putting the photographer in danger throughout the race. Their terrible negligence directly contributed to Ronald's serious injury and potential injury of the photographer.
Okay, all right. For the defense, can we have a closing statement?
Ronald King suffered an injury for poor performance, then went on to perform a string of bad decisions. And then when those blew up in his face, literally, he decided to try and get out of the contract he validly signed. The exculpatory contract is enforceable because it is clear, precise, does not violate public policy, and does not exempt either party for intentional misconduct. When Ronald checked off that contract, he was signed before the race in a completely sober state. The contract was ratified. This absolves Admiral Nelson and Elkhart Grand Prix from any liability of injury stemming from Ronald's own failures as a racer.
Right, very well done. All right, very well done. So I'm gonna break you guys up into 3 juries. We have a total of 10 people. So that means there'll be 2 juries of. 2 juries of 3 and 1 jury of 4. Where's the extra? I think they're there.
What?
Where are the extra notes pages? I need to see that notes page. Oh, there it is. Okay. When you break out into your juries, you need to answer the core questions that are on your jury notes page. And the key parts of it are this. Do you, the jury, find that Ronald King ratified the contract that he signed as a minor? A series of contracts he signed as a minor, does he ratify those? In addition, does he ratify the contract that he signed while intoxicated? And do you find the language of the exculpatory agreement to not violate public policy? In addition, did Elkhart Racing and Admiral Nelson and their sponsorship of this Grand Prix, did they have a duty to protect Ronald that they did not meet, that they violated that duty? So those are the things you have to decide. I'm gonna break you out into juries now. So we're gonna number you off. 1, 2, 3. 1, 2, 3. 1, 2, 3. 1. So there's the group of 4. You have to have 3 of 4. The groups of 3. You have to have 2 of 3. Decide. So which should be able to go to. So what we'll have jury 1 in this corner. Jury 2 up front here, jury 3 in that corner, and so you are adjourned to deliberate, and then we will finish up the trial.